In almost every state in America, lawyers have to pass one massive test before they can begin practicing law. It's called the bar exam, and it covers 8 foundational subjects. 8 areas of law that literally touch everything in your life. From whether a police officer can search your phone, to whether the terms and conditions are applicable if you scroll through and just click through on your app, to what happens if someone crashes into you while they're scrolling on TikTok while they're driving. These aren't abstract areas that matter only to lawyers. These are the rules that run our world. And here's the thing that nobody tells you. You don't have to go to law school to learn them. Hello, friend. I'm Mike Trawick, and I'm an attorney, a high school teacher, and a veteran of the United States Navy. I run a business called Law School for Teens, where I take the law and I use it to teach teenagers how to think. I teach real legal concepts to teenagers because I think the law is one of the best ways to learn how to think through problems, as well as I think it is one of the more important things for us to understand as we walk through life. You shouldn't have to pay hundreds of thousands of dollars to go to law school to understand these concepts. Today, I'm going to give you a thorough understanding of the 8 core topics that are taught in almost every law school. Before we dive in, let me give you some context. In the vast majority of states, lawyers have to pass what's called the bar exam to become a practicing attorney. A few states, like Wisconsin, Oregon, and Washington, offer alternative pathways like diploma privilege or supervised practice portfolios, but even those alternative paths require mastery of the same foundational knowledge that I'm about to teach you about today. For years, most states have used what's called the Uniform Bar Examination, the UBE test, to figure out if somebody can be a lawyer or not. The UBE is a 2-day, 12-hour standardized exam with 3 components: the multiple choice questions, essays, and a performance test where you solve a fictional client's problems. 41 jurisdictions have adopted it, and one of the biggest advantages it has is that your score is portable. You can transfer it to other states using the UBE without having to retake the whole exam. But here's what's changing. Starting in July 2026, the National Conference of Bar Examiners is rolling out a brand new version they'll call the Next Gen UBE. So it's shorter, it's 1.5 days instead of 2. It's entirely computer-based, and it puts a much bigger emphasis on practical lawyering skills like legal research, client counseling, and legal writing rather than pure memorization. The current UBE will be completely phased out after February 2028. The Next Gen UBE still tests 8 core legal subjects, which the NCBE now calls foundational concepts and principles, and it still requires mastery of the same foundational legal knowledge that lawyers have always needed to know. So these 8 core topics that I'm about to talk about today, they're not optional. They're the core of everything, whether you're taking the current UBE, the Next Gen UBE, or pursuing an alternative pathway. So here's what I want you to understand about these 8 core topics. What I like about what they do is you'll get most of these topics in your first 2 years of law school. Depending on the law school, they're going to go in different orders, right? You might do 4 or 5 at once. It all depends. But the different topics that we're going to talk about today: criminal law, criminal procedure, constitutional law, civil procedure, evidence, property, torts, contracts, all of what they do is they help you learn how to think like a lawyer. And so this is what happens as you go through this process. At the beginning, you're usually confused. You're not sure what's going on. The thinking is very different. You're a little bit overwhelmed in each and every class. It's like you're trying to drink water from a fire hose, right? There's so much coming at you so quickly. And if you have the ability to stick with it, over time, your thinking starts to change. And I can't pinpoint exactly when this happens. Okay, it's like a mystery. But I like what all of these subjects do because they make you approach law in different ways. And at some point, as long as you're able to understand the concepts and internalize a lot of the thinking, you start to see the world through the lens of thinking like a lawyer. And so that's why I like these 8 core subjects, and that's why I teach them in my Law School for Teens classes, because I help. Not only does it help you understand what goes on in a law school, but it helps you learn to think like a lawyer. So today I'm going to walk through all 8 of those subjects. I'm going to explain what each one covers, why it matters in the real world, and I'm going to give you some examples that connect to your real life. By the end of this video, you're going to understand the legal system better than most adults. Let's get into it. This is the subject that all kinds of television shows are about, right? Criminal law, what happens in the criminal legal system. Okay, so crimes are public harms. This means, yes, there are individuals who are harmed by people who do crimes. When somebody does these crimes, whether it's stealing or murder or burglary or arson, it not only harms the victim, but it harms society as a whole. Because of that, we have the prosecutor, who is the government. They represent the government. It's a lawyer that represents the government. They charge the people who are potentially have done these crimes, right? They allegedly have done these crimes. Criminal law defines what actions are crimes and what punishment goes with them, right? The purpose of criminal law is to deter people from doing them in the first place, then to punish them if they do the crimes. Once that punishment is done, they show the world what punishment happened, so it helps deter other people from doing those things in the future, right? This is basically what rules happen. If you think about rules that are in your house, right? Your parents have rules, and they have punishment that goes with those rules. If they don't have punishments, people don't actually pay attention to them that much. And those punishments might stop you from doing those rules in the first place, okay? And if you do get punished, right, because we all like to test our boundaries every once in a while, that punishment needs to be in such a way that says, hey, I don't want to do this thing anymore. That's what criminal law is about. We're trying to maintain order in our society, and we have to have certain laws that punish people who break that order. Now, with criminal law, you have the highest stakes that are out there, right? If you commit a crime, you can lose your life, liberty, or property. Okay, life if it's a very serious crime, depending on if you're a state that has, if you're in a state that has the death penalty. Liberty is your freedom, right? This is the one where if you go to jail, if you are found guilty of a crime, you go to jail and you've lost your liberty. And then property is usually a fine of some sort, depending on what type of crime you've done. You might have to pay a fine, which is a loss of property. So that's what criminal law is trying to accomplish. Now, what are the basic parts of criminal law? Well, in criminal law, we teach about the actus reus, the mens rea, and the causation of harm. The actus reus is the voluntary act that happens when somebody commits a crime. It's got to be voluntary, can't be involuntary, right? And it's a choice that is made by the person committing the act. That's why it's a voluntary act and not an involuntary act. Then there's the mens rea. The mens rea is the criminal mental state. Okay, now there's lots of levels to this. But you have to have the actus reus and the criminal mental state together. We call that concurrence. And then it has to cause the harm. Once all four of those things have happened, you have a crime. Okay. Now, each crime has elements. It can have one element, and it can have several elements. Those elements are what the prosecution, the government lawyers, have to prove beyond a reasonable doubt. Okay, beyond a reasonable doubt is the highest standard of proof. Okay, so if you're looking at the screen, and way down here at the bottom is 0%, and way up here at the top is 100%. Beyond a reasonable doubt is somewhere up here, 85 to 95%. Okay, it's not a clear black line as we call it, but what we talk about is it's got to be beyond a reasonable doubt. We can't use 100% certainty because we wouldn't be able to prove that in most cases. But beyond a reasonable doubt is a high enough standard that the government has to work really hard to achieve, and we want the government to work really hard to achieve. Remember, the government is legalized force, and we don't want them to abuse their power. So there's a tension between, hey, we need to stop people who harm society. That's what crimes are harms to society. And then we need to maintain the rights of the citizens. And so there's a tension there, and it's never going to be perfect. But beyond a reasonable doubt is a high enough standard that we think that works the best to prove. Now if there's four elements to a crime, you have to prove beyond a reasonable doubt to all four elements. If you are the defense attorney, right, the person who's defending the alleged defendant, the person accused of the crime, all you have to do is provide doubt in one of those elements. You don't have to provide doubt in all four. You just need to provide doubt for one of the four elements, if there are four elements to the crime. If the prosecution cannot prove beyond a reasonable doubt that the person is guilty, then the person walks free. They're acquitted. That's what that means. They are acquitted of the crime. So earlier I mentioned the criminal mental state called the mens rea. There's a lot of different ways to talk about this, but there are some levels that I want to share with you today. There's a specific intent crime. This means that you intended the particular result. Okay, so burglary, for example, isn't just breaking into a building. It's breaking into a building with the intent to commit a felony therein. Therein is an old word meaning inside. So if you broke in just to get out of the rain and had no intention of stealing anything, that's not burglary. It might be a different crime, but it's not burglary. General intent means you intended to do the act itself, but you didn't. You intended to do the act itself, but you didn't necessarily intend the specific result. All right, so I want you to notice the nuances going on here. That's the little thinking that learning to think like a lawyer helps you perceive. So battery is punching somebody or some type of contact. Battery is a general intent crime. You meant to make contact with the person, even if you didn't mean to hurt them as badly as you did. All right, so that's general intent. Specific intent, general intent. Strict liability is the most surprising one. Okay, for certain crimes, criminal mental state doesn't matter at all. Now, remember, I told you earlier that we really want the government to work hard to take away somebody's life, liberty, or property. So we don't like a lot of laws that get rid of the mens rea, the criminal mental state, completely. Okay, but sometimes we've decided that your mental state doesn't matter. So selling alcohol to minors is a classic example. Even if you genuinely, honestly believe that the person was 21, even if they showed you a fake ID, you can still be guilty. You did the act, and that's enough. Okay? And so in essence, what society is saying, or the lawmakers who have created these laws are saying, is that this is such an important crime that just the very act itself harms society. And so they're putting the onus on the person selling the alcohol. They're saying, hey, it's your responsibility to make sure that you don't do this. If you do the act, it doesn't matter what you're thinking, we're still going to punish you. And think about how that changes the behaviors of the people who sell alcohol, right? They're going to be more likely to err on the side of caution. They're going to say, hey, you look too young. I'm sorry, I'm not going to be able to sell that to you, because they have to protect themselves, which protects society. And so in essence, what we're saying is like, yes, there are going to be some 21-year-olds who maybe look really young and aren't going to be able to buy alcohol, but that's worth it to protect the other minors who would buy alcohol and harm themselves. All right, so we got the general idea about the different types of mens reas and the actus reas and things like that. Let's look at homicide. Homicide is one of the more heavily tested areas on a bar exam in criminal law. And it's also the area where the mental state of what's going on matters the most. So now remember too that criminal laws are handled by the states. So the state of Michigan can have different crimes than the state of Ohio, which can have different crimes than the state of Missouri. Usually what you're going to see is that there's going to be a lot of similarities. But there's going to be some differences as well. So when I talk about these, I'm just talking about these in general. First-degree murder is the most serious. So the elements to first-degree murder are usually premeditation, deliberation, and the intent to kill. So we say that this is probably one of the more serious crimes, if not the most serious crime that we have, because we do not want citizens to plan to kill other citizens. Okay? And because it's the most serious, it tends to have the highest punishment. All right? So premeditation means they planned to kill. Deliberation means they weighed the pros and cons. And the intent to kill means they had the specific intent to cause that outcome. And so if you can meet all of those elements beyond a reasonable doubt, you will be guilty of first-degree murder. Now, second-degree murder is killing committed with extreme recklessness. All right? What the law sometimes calls a depraved heart. Now remember, this can be different between each state. Think of someone firing a gun into a crowded room. They may not have had the intent to kill a specific person, but they knew or should have known that doing that action could harm somebody. And their conduct showed an extreme disregard for human life. And the law treats that as murder. Now, that's not going to be as serious as intentionally killing a specific person, but it's going to be pretty serious. And so depending on the state, you can get life in prison. You might be able to get parole. You might get a number of years. But second-degree murder is going to be a lesser charge or a lesser punishment than first-degree murder. Now, voluntary manslaughter is the crime that kind of says, hey, human beings are emotional. Okay? So what happens with voluntary manslaughter is there is a reasonable provocation. So there is some type of action that provoked you to create a heat of passion, an emotional state where you could not control yourself. So there was an adequate provocation. Usually it's going to be something like finding your spouse cheating, a serious crime to a close relative counts, and also mutual combat. Sometimes in the middle of a fight, you can get into a heat of passion. There's going to be others. Again, states can decide how they want to describe this. But there's an adequate provocation, which leads to a heat of passion. Heat of passion is an intense emotional situation where you cannot control yourself. There was no time to cool off, and you did not, in fact, cool off. And you killed somebody. And so what we're saying here with voluntary manslaughter is, listen, we get it. You're emotional. and you couldn't control yourself. And we understand because it's a reasonable provocation. This doesn't happen. You aren't allowed to use voluntary manslaughter anytime you become super emotional. It's a limited crime. It says specifically there are some adequate provocations, and the states get to decide what those adequate provocations are, that lead to an emotional state that you couldn't control and you did the bad thing. And we're saying, you know what? We get it. You're a human being. You're emotional. You're not going to get away with it, but we're not going to punish it as high as we do first degree or second degree murder. All right. And then there's involuntary manslaughter. Now, involuntary manslaughter tends to be the lowest level of homicide that we allow. It's an unintentional killing caused by recklessly or criminally negligent conduct. All right. So texting while driving and then killing somebody is going to be considered involuntary manslaughter. Now, states can call this all kinds of things, vehicular manslaughter, things of that nature. But for our purposes, involuntary manslaughter is how we'll describe it. So those are your basic ones. Then there's a law that comes into it when we're talking about murder called felony murder. Now, this may or may not be in your state. This is controversial, meaning some people agree with it, some people disagree with it. So if someone dies during the commission of a dangerous felony, usually there's a list of dangerous felonies. Burglary, arson, robbery, rape, kidnapping are like your core dangerous felonies. They can be charged with murder, even if they didn't intend for anyone to die, and even if they weren't the one that caused the death. Now, this is very controversial, like I said earlier. It's also different depending on what theory you use in every state. But the idea is we are trying to deter people from doing dangerous felonies. Dangerous felonies are ones that can have the likelihood of death happening. And so we don't want people to do them in general. But the idea is that felony murder is there to stop you from doing it even further, right? We're always trying to deter crime from happening in the first place. The problem with felony murder is that people say, hey, they don't have to form the mens rea of murder, right? Which is intent to kill. And so you are making it easier for somebody to punish them with life in prison, which is usually what the punishment for felony murder is. So there's a couple of, let's look at a couple of examples that might apply with felony murder. So let's say 3 people are robbing a bank and one of them accidentally shoots a bystander. All 3 can be charged with felony murder depending on the jurisdiction you're in. Or even more extreme, if a security guard shoots and kills one of the robbers, the surviving robbers can be charged with murder of their accomplice in some jurisdictions. That's how far felony murder can reach. So this is an example of lawmakers trying to figure out a way to get people to stop doing these dangerous things. And there's a debate on whether this is the right thing to do or not. Those are some of the crimes that you can find in criminal law. Let's look at some of the defenses. All right. So a defense happens when somebody has committed a crime. You don't just walk into a police station on a random Tuesday and say, hey, I'd like to claim self-defense. And they go, oh yeah, well, did you commit a crime? No, I just like to claim self-defense. That's not how it works. First, you have to have committed a crime. Then you have to have a situation where either you are not responsible for your actions. That's where we talk about insanity, intoxication, infancy, which is you're too young to develop the mens rea usually. So you're not responsible for your actions, or you're justified or excused. And there's a lot of defenses in this area: self-defense, necessity, duress. All of these types of defenses mean you're justified or excused in your actions, and you are probably acquitted of the crime if you can prove those defenses. Criminal law is fundamental in understanding how society draws the line between acceptable and unacceptable behavior, and what happens when you cross it. All right, let's move on to the next one: criminal procedure. If criminal law tells us what's illegal, criminal procedure tells us how the government has to go about catching, charging, and trying and punishing people. Okay? And this is where your constitutional rights as an individual really come to life. So criminal procedure is roughly half of all questions between criminal law and criminal procedure. And for good reasons, right? These rules protect everyone, not just people accused of crimes. Every time a police officer pulls you over, searches your car, asks you questions, criminal procedure governs what's happening. The heart of criminal procedure is the Bill of Rights. Let's go through the amendments that matter the most here in criminal procedure. First and foremost is the Fourth Amendment. The Fourth Amendment was created by the founders in response to something called a general warrant or a writ of assistance. These were warrants given to British government officials back in the day when we were colonies that said, hey, we can search anybody we want, we can arrest anybody we want. And this was an abuse of power. You can see how any human being over time, even if they're the best human being ever, could abuse that kind of authority. Okay, so in the as they had the argument, the framers had the argument about ratifying the Constitution, there was a side that said, hey, listen, we need to add a Bill of Rights. And so in 1791, they added the Bill of Rights. And the Fourth Amendment was one of these Bill of Rights. And it says, we the people are secure. Secure means we don't need, secure means we are free from government interference. All right. In our home, our persons, we are free from government interference in our persons, houses, papers, and effects from unreasonable searches and seizures. Okay, that's really the big thing. If it's unreasonable, the government can't do them and they need a warrant. If it's reasonable, the government can do them and they don't need a warrant. So in criminal procedure, we learn, okay, what does that mean? What is an unreasonable search? How do we figure that out? Right? And what we find is there's a court case called Katz v. United States, that says, hey, if you have a reasonable expectation of privacy in a certain action or in a certain place, then the government needs to get a warrant before they can invade that space. If you do not have a reasonable expectation of privacy, then the government doesn't need a warrant. So the question is, how do you figure out if you have a reasonable expectation of privacy? Well, it's a two-part test, which has been added on to since then, but for our purposes, a two-part test. First, does the individual have a reasonable expectation of privacy? Think about you sitting in your house. Do you have any individual expectation of privacy from government interference while you are in your house? Absolutely. Right? I think that's clear cut. It's one of the things listed in the Fourth Amendment. But then, is society willing to recognize that? Well, think about society as a group of people standing outside your house, looking at it going, should they have a privacy in that situation? The answer is yes, right? Society is willing to recognize that. Therefore, especially in the home has the highest level of protection in the Fourth Amendment, okay? Now consider this with somebody who is in prison. So the question is, would a prisoner have an individual expectation of privacy? Well, they might. In some situations, they might expect that, hey, I should have some privacy in this situation. But the second question, is society willing to recognize that, is going to say no. Because these people have harmed society in some way. They had a crime. They've been found guilty. Now they're in prison. And so guards should not have to get a warrant every time they wanted to do a search, because there's a need for safety and protection of not only officers, but maybe other inmates, depending on how dangerous situations are. And so you don't have to get a warrant every time you want to search a prison cell. So those are kind of the examples of what you learn in the Fourth Amendment class. But here's the reality. The exceptions to the warrant requirement are almost as important as the rule itself. So there's a bunch of exceptions that you learn about in criminal procedure. Search incident to a lawful arrest. If you are lawfully arrested, police can search you and the area within your immediate reach. There's plain view. If an officer legally present somewhere and they see evidence of a crime sitting out in the open, they can seize it. Consent. If you voluntarily agree to a search, no warrant is needed. The automobile exception. Because cars are mobile, police can search them with probable cause but without a warrant. Exigent circumstances. If there's an emergency, like evidence about to be destroyed or someone in danger, the police can act without a warrant. And then there's Terry stop and frisk. This is based on the 1968 Supreme Court case Terry v. Ohio. Police can briefly stop and frisk you if they have reasonable suspicion. So that is below probable cause. Reasonable suspicion are objective facts that are articulable. Probable cause is a little bit higher than that. There's got to be some evidence of that a crime is about to happen. There's some different definitions for probable cause. It's a fluid thing, kind of like beyond a reasonable doubt was back in the criminal law section. But if police officers have a reasonable suspicion that there might be some type of criminal activity going on, they could stop you, pat you down, ask you questions. And if they can't develop probable cause from that, then they have to let you go. All right. That one's controversial. People don't like that because it can be abused. Again, we see a constant tension between individual rights of the people and the need to protect and maintain order and to try to find crimes before they happen. Okay, so that's that that's that tension that we see in the Fourth Amendment. So one of the issues with the Fourth Amendment is that it doesn't have a punishment. As we talked about in the criminal law section, rules have to have punishments for people to follow them consistently. Right? And so the courts developed, it started in a case in 1913, 1914 called the Weeks v. United States case. They came up with something called the exclusionary rule. It wasn't applicable to the whole United States until 1961 Matt v. Ohio case. But the exclusionary rule says if the police do an illegal search, meaning they do a search when they should have had a warrant but they didn't, any evidence they find cannot be used in court. It's excluded from trial. And you got to remember that the whole purpose of collecting evidence is so that the evidence can be used at trial to present to the jury to find the person guilty. Right? So if we exclude that evidence, ideally what that does is deter the police from doing illegal searches. Really, what's interesting about the exclusionary rule is it harms society, because very rarely, right, will somebody want to exclude evidence that makes them look innocent. So all the evidence that gets excluded is the evidence that makes people look guilty, which implies that the people who get evidence excluded would have otherwise been found guilty and would have been punished. And that helps society. So again, you're seeing this tension. Okay, how do we make sure that the police don't abuse the power, but they are able to do the job that they have? And so the exclusionary rule may or may not be the best way to do that, but it is a rule that we have to follow. So after the Fourth Amendment comes the Fifth Amendment. Now, the Fifth Amendment has a lot going on in it. Most of it has to do with criminal law. But there's also the takings clause, which just shows up in there at some point as well. So the Fifth Amendment gives you the right against self-incrimination. One of the things it does is give you the right? I plead the Fifth, right? You cannot be forced to testify against yourself. This is part of where the Miranda warnings came from. Now, before a case called Miranda v. Arizona in 1966, police did not have to read you your rights, all right? In 1966, the Supreme Court ruled that before police interrogate somebody in custody, they have to inform them of their rights. They have the right to remain silent. The warning that you say, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. And if you cannot afford one, one will be appointed to you. If the police don't give the Miranda warnings before a custodial interrogation, then any confession that might be used cannot be used in court. It's going to be excluded under the exclusionary rule. But the thing, and now I'm not, I am an attorney, but I am not a police officer. And so I don't know what the practices are. But on TV, you always say, right when people get arrested, you'll see you have the right to remain silent, right? Anything you say can and will be used against you. That's actually not when they have to give the Miranda warnings. Now, maybe that is police procedure. I don't know. If you're a police officer, drop it into the comments. Let me know if that's a thing that you have to do. But when you have to give your Miranda warnings, and I assume you would have to do this again, is when you go for an interrogation that is custodial. Custodial means you're under arrest usually, okay? Interrogation means you're about to ask questions, okay? And so that is when you have to have your Miranda warnings, not when you get arrested at the first time. Now, the Sixth Amendment gives you the right to a lawyer. So what's interesting here is this right attaches once formal charges are filed and covers every critical stage of the criminal process, right? And it's not just the right to any lawyer, it's the right to an effective assistance of counsel. So this first came about in 1963 in the Gideon v. Wainwright case, very famous case. It's you should check out the details. I'll probably do a video about it at some point on this channel. But that was the case where Gideon was the person accused of a crime. He couldn't afford an attorney. He had to represent himself. He got sent to prison. And his case made it all the way up to the Supreme Court. It was very unusual because he did a written form of the writ of cert, which is how you get permission from the Supreme Court to get access to them so that they will listen to the trial or listen to the case. And he won. And so he got access to a lawyer and he was acquitted. And the lawyer got him off relatively easily. And so the concept here is why do you have an attorney? And it's very interesting. So the government has an attorney for criminal law, right? Now, this only applies in criminal law case. You do not have the right to an attorney in a civil law case, which is where I'll talk about this later, or I'll talk about this in another section, where you are suing somebody for financial damages usually, right? When there's a medical malpractice or somebody, there was a car accident and there wasn't insurance involved, something of that nature, where you're trying to make yourself whole. That you don't have the right to an attorney there. You have to pay for your own attorney in that situation. But in a criminal sense, one of the arguments was, hey, the government hires a lawyer to navigate the legal system. And if the government needs a lawyer to do that, why wouldn't the defense need one to put them on equal footing, right? We don't want the government to be overbearing. Now, they still have all the power, right? They still decide when to bring charges. That's going to be a constant unfair advantage in the legal system. But giving the defendant an attorney helps kind of balance that out. All right? So that's why you have the right to an attorney, and that's said in your Sixth Amendment rights. So criminal procedure is the set of rules that prevents the government from becoming a police state. It balances out the need for public safety against the fundamental rights of the individuals. Like I said, that constant tension that we have to have. Every teenager should understand how these protections work because they apply to you right now. Constitutional law is the foundation of everything, right? The Constitution is the highest law of the land. It outranks every statute, every regulation, every state law for the most part, every executive order. Any law that contradicts the Constitution of the United States of America is unenforceable. That's what we mean by unconstitutional. Constitutional law, or con law as we call it when we go to law school, covers two big sections. At least this is how it was broken down in my law school. There was con law 1, con law 2. Con law 1 talked about the structure of the government. Article 1, Congress, right? The House of Representatives, the Senate, how they work, how they make a bill into a law, and the various roles that they have. Article 2 is the executive branch. That's the president. What can the president do? What can the president not do? Article 3 is about the judicial branch. Article 3 is about the judicial branch. It creates the Supreme Court. It gives it original jurisdiction in a few areas and appellate jurisdiction in a lot of areas. And it tells exactly what types of cases that the Supreme Court can rule on. Article 6 is the Supremacy Clause. Article 4 talks about full faith and privilege. There's a bunch of different stuff in the article, but the big three are Article 1, 2, and 3, which lay out the three branches of our government, creates the separation of powers, creates the checks and balances, all that good stuff. The second area of con law is the rights. First Amendment, Second Amendment, Third Amendment. Fourth Amendment is usually covered in criminal procedure. Fifth Amendment, Sixth Amendment, also in criminal procedure. Seventh Amendment doesn't get touched on a lot. Eighth Amendment might get touched on depending on what your law school might talk about. 14th Amendment also gets touched on in con law too. Let's talk about a couple of the amendments that are very important to the Bill of Rights. So the First Amendment, right? Most of us know it as the freedom of speech, okay? But it actually has 5 rights that it protects. Now, what you need to understand is what the Bill of Rights does is limit the power of government. Government is the most destructive force in history. If you go back and you look at all the destruction that's happened, it's because governments have made decisions to act in certain ways. So the idea with the founders is that they're saying, hey, we need a central government that's strong. So let me go back a little bit here. We declared revolution. We revolted from the British with the Declaration of Independence. Now, before that, we had tried to stay Englishmen. We tried to stay connected to them. There was a lot of communication and talk with the British government, but the British government and King George ignored it for the most part. At least that's the perspective from the U.S. So we declared independence. We said, hey, you know what? The purpose of governments is to secure the rights of these people. The purpose of government is to secure the rights of the people. Among these rights, so not all the rights, but among these rights, is the right to life, liberty, and the pursuit of happiness. Okay? And if the government's getting in the way of that, then we, the people, have a duty, a responsibility, and a right to revolt. But we don't do it for light and transient reasons. Okay? That's what the Declaration of Independence says. We only do it when we can no longer take any of the tyrannical actions that the government is throwing upon us. And then they gave 27 grievances, and they said, hey, this is what the king has been doing to us. And then they said, hey, it's upon our sacred honor that we are declaring independence. And 56 men signed that declaration and put pretty much death warrants on their backs because now their names were known to the British government. And they went to war. Or they were already during war. They were already in war, but continued the war at the time. Well, then they created a government called the Articles of Confederation. The Articles of Confederation was in response to the British government. The British government was tyrannical in their mind. In a very simplified form, tyrannical means too much government interference with our daily lives. Okay? So the Articles of Confederation said we don't want a strong central government. We're going to give more power to the states or the colonies at the time, right? Started to call them states under the Articles of Confederation. And so that the states had more power, not the central government. And this was a mess, right? And we got rid of that government within 8 years, okay? But what happened was we realized that there had to be the central government had to be strong enough to do the things that the government needs to do. So government has been called a necessary evil. And I think that's probably the best way to think about it. And because it's a necessary evil, the core part, the articles of the Constitution, Articles 1 through 7 that I was speaking of earlier, create the government and list out its powers. Article 1, Section 8 says, hey, these are all the powers that Congress has, right? These are the things that are called enumerated powers. And these are the things they can do. That's it, right? And so, but there were some people who were like, you know, we don't like this. We just lived through a tyrannical government, and we don't want that to happen again. So we need a Bill of Rights that limits the power of the government. Okay, so The first through 8, the 9 and 10 are also important to this, but the 1 through 8 are usually considered individual rights. And so I want to talk a little bit about the First Amendment, and I want to talk a little bit about the Second Amendment for the purpose of this video. The First Amendment, most people think of it as just the freedom of speech, and it's not. The freedom of speech actually is the third thing that they put in the First Amendment. They actually say the government cannot establish a religion, and we can exercise religion freely as citizens. Then we have the freedom of speech. Then comes the freedom of the press. Then comes the right to peaceably assemble and to petition the government for redress, or to say, hey, government, we need this problem fixed. So that's what the First Amendment protects. It says Congress shall make no law. Okay, I want you to think about that. Congress's only job is to make laws. So it says, hey, you can't do your job, Congress, in this area. Now, that's not precisely true, because our rights are not unlimited. Right? Rights come with responsibilities. And so there are things, and that's what you learn when you study the First Amendment, there are things that the government can make laws about when it comes to speech that they can punish. Right? So the First Amendment says, hey, we can speak without interference with the government for the most part. Unless you are fighting words, though that's very limited. You're trying to incite violence. There's something called defamation, which harms reputations. You can't do that kind of thing. So there are laws that can be made. Rights are not absolute. But without question, without a doubt, at the time of this recording, the United States has the greatest protections for the First Amendment and the freedom of speech anywhere in the world, bar none. Right? And you can just look over at the United Kingdom and how 12,000 arrests have been made about social media posts that people didn't like over there. Right? That would not happen here in the United States, because the First Amendment protects against that. Now, the biggest, I think, and the most important amendment is the Second Amendment, right? And this protects the right of the people to bear arms. So I'm going to talk about this one for a little bit. The Second Amendment is actually very interesting when it comes to a legal standpoint. For a long time, there was a doubt that there was an individual right versus a collective right. So an individual right is you individually can own a weapon, usually for self-defense or to go hunting or whatever. You don't actually have to have a purpose. You can own a weapon. That's what you can do. But then there was some people who said, no, it's a collective right, meaning you should only be able to own a weapon if it's associated with a militia, because the point of the Second Amendment was to defend the states without having to have a standing army. At the time the founders created the Constitution, they weren't big fans of standing armies. Standing armies were the redcoats of the British, and they associated those with oppressing the people, right? Because if you had a lot of redcoats walking around town, they could keep an eye on people. So the founders did not like a standing army. They liked the idea of a militia. We now have a standing army here in the U.S., but at the time they associated, hey, you need a gun as a militia member, and only as a militia member. Right? That's the argument for people who think it's a collective right rather than an individual right. Well, that was put to bed in a series of cases. So the first case was in 2008. Okay, so I want you to think about this. We got the Bill of Rights in 1791. So from 1791 to 2008, we were not clear that it was an individual right. Second Amendment advocates are people who say that you should be able to own a weapon in any way, shape, or form with some limitation. Obviously, like I said, no right is absolute. Gun control advocates are people who say, hey, very few people should be able to own weapons. Now, that's a very oversimplification, but it works for our purposes. So in the court case District of Columbia v. Heller in 2008, the court finally said, hey, it's an individual right. So what they did was they looked at the text, the history, and the way that the founders understood the Second Amendment, and they concluded it as an individual right. All right? You didn't have to be in a militia to exercise it. It belongs to ordinary citizens for traditionally lawful purposes, including self-defense in the home. But the problem with Heller is that it didn't incorporate the right to the rest of the United States, because Washington, D.C. is a federal district. So it only applied really in a federal area. Okay? Federal means national government, right? The federal government, there's two levels of government that we have here in the U.S. We have the federal government out of Washington, D.C., and we have state governments. And I put them like this. I don't put them like this because it's like having two governments over the same land, but they do different things, right? The federal government is kind of outward facing or a general facing for all the states, where state governments are focused on what they do within the borders of their state. Some of their powers overlap, but not a lot of them. So before I dive into the McDonald case, which comes after the Heller case, and it incorporates the Second Amendment and makes all the states have to follow it, let's talk about what incorporation is. So for the longest time, it was the federal government and the state government. So remember, the framers are about separating power. They don't want power in one person, one entity, because that's how power gets abused. So we want to separate it, and they create checks and balances and tension upon themselves. So there was a thought process that if it applied to the federal government, it did not automatically apply to the state governments, right? And so for like the first 80 years or so, the idea was that the Bill of Rights didn't necessarily apply to all the states. Now, the states have constitutions as well, and they can incorporate some of those Bill of Rights into their constitutions, and a lot of them have, but they don't have to follow the federal Bill of Rights. Well, we had the Civil War, and after the Civil War, the federal government realized that we've got to be able to force states to do things, because we have a bunch of slave states that are coming back into the Union who might abuse our now citizens of the United States, the black citizens at the time. And so the 14th Amendment said, you know what? The states can, or the federal government can force the states to do certain things through the 14th Amendment. Okay, it's called incorporation. Well, they didn't incorporate all the rights at once. It had to go case by case. The first one was in 1925, a Gitlow case. It said that the states now have to follow the First Amendment. Well, it wasn't until 2010 that the Second Amendment was incorporated and enforced on all the states. And that was McDonald v. City of Chicago. And so in that case, the city of Chicago tried to limit the ability for citizens to have guns in their own homes for self-defense and things of that nature. And there was a lawsuit. It came shortly after the Heller case. It went right before the Supreme Court. And the Supreme Court said, listen, the Second Amendment has to be followed by the states. And so now it's an individual right allowed in all of the states. The Second Amendment is. Then in 2022, there's the New York State Rifle and Pistol Association v. Bruen. We're just going to call it the Bruen case. That changed how the courts evaluate gun regulations entirely, because this is a very tense topic. Gun control advocates try all they can to limit guns, and Second Amendment advocates try all that they can to allow more guns to be purchased and used freely, right? I'll leave it up to you to decide which side you fall on. But the Supreme Court with the Bruen case, before the Bruen case, there was a balancing test on whether or not the gun control law was applicable or not. They would weigh the government's interest against the burden on the right of the individual. The Supreme Court said, hey, we're not going to do that anymore. Instead, they said when the Second Amendment's plain text covers someone's conduct, the government has to justify its regulation by pointing to a historical tradition of similar restrictions from the founding era or the period surrounding the 14th Amendment's ratification. If you can't find a historical analog, the regulation is unconstitutional. So this is a huge shift, right? It put the Second Amendment on similar footing with other fundamental rights where the government bears a heavy burden to justify restrictions. Okay, so the idea why we have First Amendment freedom so much is because the government can't restrict your reading. The biggest purpose of the First Amendment is to be able to criticize the government, right? If you pay attention to politics at all, you know that if you don't like, I'm recording this in 2026, so if you don't like President Trump, you can say all the things. I mean, your mother and father might not want you to say those things, but you could say them, right? Same thing went with President Biden and Trump before, and then President Obama, and so on and so forth. Historically, we've always trashed politicians, okay? And you have that right. Part of that is we need to get our voice to the government. The government is supposed to serve the people. Remember that the government exists to secure the rights of the people. And so we need to be able to tell the government if we like a thing or not. We do that through elections. We do that through freedom of speech. We do that through all kinds of ways. Now, the biggest argument to contain or continue the freedom of speech is having the Second Amendment. The idea is that the Second Amendment allows you to have that right of revolt that we talked about earlier ready to go. You do not revolt for light and transient reasons. But remember, we divide power in the United States. So there's division within the government, right? We have the three branches. We have states versus federal government. But there's also a tension between the people and government. If the government is no longer securing the rights of the people, we have the right to revolt. How do we revolt if we don't have guns? That's the idea behind the Second Amendment protections. Constitutional law. It's about understanding how the government functions. And it's about understanding the legal rights that you have when it comes to your amendments. So every major debate in American life, free speech online, privacy rights, executive power, voting rights, gun regulations, is ultimately a constitutional law question. That's why understanding the Constitution is so important for you in your everyday life. Let's move on to contracts, which is another one of the subjects that you're going to see in your first year of law school, more than likely. Not only that, contracts is probably one that you should understand anyway, because regardless of if you ever become a lawyer, you are going to have to deal with contracts. Every time you make a deal, every time you accept a job, every time you sign a lease, every time you buy a house, a contract is involved. At its core, contract law answers 4 questions. Was a valid deal made? What did the parties promise? Did something break? Did someone break the deal? And if so, what's the remedy? In essence, a contract is the promise that the government is willing to enforce. There's a lot of definitions for contracts, but that's probably the most basic and simplest one. When we talk about a contract, we talk a lot in contract law about its formation. There are 3 basic things that you need. There needs to be an offer, there needs to be an acceptance, and there needs to be consideration. An offer is a proposal. I'll sell you my car for $10,000. It has to be specific enough that the other person can simply say yes. A vague statement like, I might sell my car someday, is not an offer. Acceptance is agreeing to the offer. Here's an interesting topic within the area of acceptance called the mailbox rule. Under common law is judge-made law. An acceptance is effective the moment it's sent, not the moment it's received under the mailbox rule. If you mail a letter accepting a deal, the contract is formed when you drop the letter in the mailbox, even if the other side hasn't read it yet. Sounds old-fashioned, but the principle still applies to modern communications in many situations. Now, consideration is exchange of value. Each side gives something of value, okay? If I'm buying the car, right, I give you the car. I'm sorry, if I'm selling you the car, I give you the car, you give me money. Both sides get something that is exchanged of value. Right? If I promise to work for you, you promise to pay me. If only one side is giving something, you're getting nothing in return, that's a gift, right? Not a contract. There's no legal obligation to follow through with a gift. But there is an important exception called promissory estoppel. If someone makes a promise and you reasonably rely on that promise to your detriment, so it hurts you, right? You change your plans, you spend money, or give up an opportunity because of that promise, a court can enforce that promise even without formal consideration. The classic example is an employer tells you, we're going to hire you, go ahead and relocate to our city. You quit your current job, you move your family, and then the employer says, just kidding, never mind. Promissory estoppel can protect you in that situation and force the company to at least provide for you your moving costs and things of that nature, because you wouldn't have otherwise done that thing if they hadn't made the promise. Now, even if a contract has an offer, acceptance, and consideration, there are reasons a court might refuse to enforce it. These are called the defenses to enforcement. There might be incapacity. Minors generally cannot be held to contracts. If a 16-year-old signs a contract, in most cases they can walk away from it. Same with someone who lacks mental capacity. Duress. If someone forces you to sign a contract under threat, it's not enforceable. Fraud. If someone lies to you about material fact to get you to agree, the contract can be voided. Fraud. If someone lies to you about a material fact, material in this case means very important to the contract, and they lie about that material fact to get you to agree, the contract can be voided. Mutual mistake. If both parties are wrong about a fundamental assumption underlying the deal, the contract may be voidable. Unconscionability. If the terms of the contract are so outrageously one-sided that no one reasonable person would agree to them, the court can refuse to enforce it. This comes up a lot with consumers contracts where massive corporations buries unfair terms in the fine print. So those are some of the defenses that you can have to contracts, and that's what you would study in contract law. Then there's something that's interesting called the statute of frauds. Statute is a word that means law. And this is one of the oldest rules in contract law. So once people started to learn to read and write back in the day, remember, not everybody was literate back 1100s, 1200s, 1300s. Whenever they started to become literate, the law required contracts to be in writing more often. And under the statute of frauds, there are some areas that absolutely must be in writing. Otherwise, they are not enforceable. So contracts for the sale of land would be included in there. Contracts that can't be performed within 1 year. Contracts for the sale of goods worth $500 or more. and a few others. If the contract falls into one of these categories and it's not in writing, it generally cannot be enforced, no matter how clearly both sides really agreed to it. And when we get to the sale of goods, there's a whole nother article that makes contract law a little more complex. So most contract law comes from common law, judge-made rules built up over centuries. But contracts for the sale of goods, tangible, movable items like cars, furniture, electronics, clothing, are governed by what's called the Article 2 of the Uniform Commercial Code, the UCC. The UCC is a standardized statute adopted in all 50 states, and its rules differ from common law in some important ways. So, for example, under common law, acceptance has to match the offer exactly. It's called the mirror image rule. So if one side makes an offer, the other side has to agree to that offer for it to become a contract. Okay? And so if you change up any of the two, so if one side makes an offer, says A, B, if one side makes an offer, says, how about A, B, C, and D? And the other side says, I like A, B, and C, but what about E? Now you don't have a contract because they're not exactly the same. So the other side, it flips, it becomes a counter offer, and then these guys have to accept. They say, okay, we'll take A, B, C, and E. Now it becomes a contract. Okay? Under the UCC, additional terms in an acceptance can become part of the contract automatically between merchants. Merchants tend to have some sophistication. They're different than your common, ordinary persons. And so there's some acceptance, there's some leeway, some flexibility, so it doesn't have to be perfectly mirror-like within the contract. So about 1/4 of contracts questioned on a bar exam will come from the UCC. So knowing the difference is really important. Now, let's talk about what happens when somebody breaks a contract. This is called a breach of contract. The main remedy, the main solution to when a contract is broken is expectation damages, putting the injured party in the position they would have been if the contract had been performed. Okay? If I agreed to sell you a car for $10,000 and then backed out, and you had to buy a comparable car for $12,000, your expectation damages would be $2,000. That's the difference between the two numbers. Then there's also, under contract law, something called specific performance. A court ordering requiring the breaching party to actually do what they promised. So what does this mean? Now, this is rare, and it's usually reserved for unique items, especially real estate. But if I agreed to sell you a specific piece of land and then refused, a court might order me to go through with the sale because land is unique. You can't just go buy the same piece of land somewhere else. And then finally, there's another idea in contract law that you'll probably learn about if you go to law school, and it's called the duty to mitigate. A duty is a legal obligation. All right. So the duty to mitigate means if someone breaks a contract with you, you can't just sit back and let the damages pile up. You have a legal obligation to take reasonable steps to minimize your losses. If your employer fires you in a breach of your contract, you have a duty to go look for another job. You can still sue for damages, but the court will reduce your award by whatever you could have earned through a reasonable mitigation. So if you could have found another job in a reasonable amount of time and then gotten paid for that, the court is going to mitigate the damages. They're going to lower the damages that the employer has to pay for you because you didn't go do what your obligation was, which is duty to mitigate. So listen, contracts are the backbone of all kinds of economic activity. All right. Every business deal, every employment relationship, every purchase that you make, it all runs on contract law. And the more you understand it now, the better equipped you'll be to protect yourself in every deal you ever make. Right. So contract law is really important to understand. Torts. This is a topic that nobody knows about outside of lawyers and going to law school. At least in my experience, I didn't know what a tort was until after I went to law school. But torts is a foundational subject in law school. I would argue it's the basics of understanding how to think like a lawyer. A tort is a private wrong. Okay, a crime is a public wrong. So when I say it's a public wrong, it's a crime against the public, the society as a whole. Okay, it's a harm against society as a whole. A tort is between two parties. It can be more than two parties, but for our purposes, we'll just talk about two parties. It can be between two individuals. It can be between two individuals, or it can be between two companies, or some kind of variation thereof. Okay. What the idea of tort law is to make somebody whole. So what's happened is some type of harm, and it was a private interaction. Now it can be a crime as well. You can sue. You can have something be a crime as well as a tort. The crime is punishable by the public system, right? And you can lose life, liberty, or property, depending on if you are found guilty. The tort is to compensate you for what you lost or damages that you might have. So I always think about it this way. When I'm teaching the class, you'll see my hands come up like this. And I say, usually what happens with a tort is that you are walking along, the victim, the plaintiff in this case, is walking along, and through no fault of their own, suddenly they have lowered an amount, they have lost some money somehow. So there was a car accident, then they were hurt, and they had medical bills, and they were out of work, and now they can't function like they used to, and so they were here, and now they're here, okay? And so the point of, so what happens during a tort is that you are here at this point. If you're the plaintiff, the person who gets harmed during this situation, you're here. And this is the amount of money you have, so to speak. And then what happens is something happens, like a car accident, or there's medical malpractice, a doctor does something wrong, or you get hurt at work, and suddenly you're down here with money. And so either you have medical bills, or you're not able to make as much money because you can't work, something like that. And it's somebody else's fault, the defendant in this case. The defendant is the person you are suing. So then the plaintiff tries to sue to make themselves whole. And so they are only supposed to get the amount of money that makes them whole and allows them to function as if they hadn't had the accident happen in the first place. Now, this is not a perfect system. Money doesn't always change the fact that you will have a limp from a car accident for the rest of your life, or you won't be able to play basketball, and maybe you did play basketball all the time. Things of that nature. But the idea is that money is supposed to compensate the best you can. All right? So let's break torts down into its two major categories that are really important to us at this point. One is intentional torts. All right? These are exactly what they sound like. They are wrongs committed on purpose. So some of these can also be crimes, like battery and assault. Battery is an intentional, harmful, or offensive contact, which could be a crime or a tort. You get punished for the action as the crime, right? You punch somebody in the face and all that stuff. But the tort maybe sues for medical damages because when you were punched in the face, you lost a tooth and you had to get that replaced or something of that nature. So the tort compensates you for the financial losses that you have due to the crime. Okay. You might also have false imprisonment or intentional infliction of emotional distress, which are intentional torts. And so you have something that's happened that's caused you some type of distress, and we are giving you money to compensate for that. That's an intentional tort. These are very small areas of law. You don't see a lot of these become lawsuits. There's also defenses to intentional torts that include consent, self-defense, defense of others, and necessity, which are very similar to the criminal defenses that you find. The bigger area of tort law is called negligence. Okay, this is the most common tort, and it's the most heavily tested topic on any bar exam because it is a fascinating area of law. It's really fun to think through, and this is the area that really starts to make you think like a lawyer, which is why I'm a big fan of torts to help you think like a lawyer. Now, negligence is made up of four elements: duty, breach, causation, and damages. So duty is, do I have a legal obligation in any situation? So when you are talking about a duty, think about driving, right? For those of you who are old enough to drive and those of you who are thinking about driving, you have a responsibility to drive safely for those, not only for yourself, but for those around you as well. And so that's the duty of care that you are expected to have. If you are texting while driving, if you are not paying attention while driving, if you're not checking your mirrors while driving, if you aren't using your blinker while driving, all of those might be grounds for a breach of the duty. So you had a legal obligation to drive carefully, and sometimes you didn't, especially if you're texting while driving. That is a breach. All right, now you've breached the duty. Now the next question is, did that breach cause the harm? And there are a couple different ways that we weigh the causation. Causation is a very complex area. I won't get into it here, but it is very interesting. I enjoy teaching that area. So if it causes the harm, did it lead to damages? Are there damages that the court can remedy? Can they offer you some type of solution? If there aren't any solutions, then you don't have a case. So you got to have duty, breach, causation, and damages as part of your negligent case. Once that happens, you have negligence and you can sue for the negligence and hopefully to get compensated for your damages, for your losses. Now, one of the other interesting, and there's a lot of interesting areas in torts. I'm not going very deep into torts at all. There's a whole bunch of areas that you can find if you go check out my courses on my website, lawschoolforteens.com. But There's another interesting area is, okay, how about comparative fault? So when negligence happens, negligence is squishy, meaning like you and I could disagree about certain things. We can weigh some facts heavier than others. There's a lot of disagreement in the area. And so when we think about the damages, the financial damages, the jury will, depending on what jurisdiction you're in, so what state you're in could change how this is done. But there's something called comparative fault. So in essence, did the plaintiff cause some of the issue? Okay. If the plaintiff caused some of the issue, well, they shouldn't get the whole reward or whole award for damages. Okay. So let's say that there was some type of issue, and the jury said, hey, they should get $100,000 in damages. But the plaintiff is 20% at fault, while the defendant, the person being sued, is 80% at fault. Well, if the total damages are $100,000, there are some jurisdictions that say, hey, you know what? It's not right that the defendant pay that whole amount. So what we should do is subtract the percentage of fault from the total. So 20% plaintiff's fault. Plaintiff is the person doing the suing. Then we take from $100,000, we take $20,000 of that out because that's 20%, and the plaintiff will only get $80,000 because they were also at fault for the whole situation. Okay, and that's what we call comparative fault. So tort law protects you every single day. Every time you drive a car, every time you walk into a store, every time you use a product, visit a doctor, or read something online, tort law is the safety net operating in the background. All right? Understanding it means understanding the legal system's primary tool for holding people and companies accountable when they cause harm. All right, let's move on to the sixth subject, property law. So property law is one of the more practical areas of law that you'll ever encounter because it governs the things you own. And I mean all the things that you own, right? The law divides property into two major categories, real property and personal property. So real property is land and everything permanently attached to it. Buildings, houses, fences, fixtures, and even things grown on land that, like trees. Personal property is everything else. Your car, your phone, your clothes, your money, your furniture, your dog. All of those things are considered personal property. The bar exam focuses heavily on real property, but personal property law shows up across all kinds of different subjects along the way. Let's start with real property. If you've ever wondered who truly owns land, what rights a renter actually has, or what happens when somebody stops paying our mortgage, that's all real property law. Unlike most other bar exam subjects where one or two topics dominate the questions, real property is distributed roughly equally across 5 major categories. Each one accounts for about 20% of the questions, which means you have to know all of it. Or at least at the time of this recording, that's what the case is. So let's start with the most notoriously complex area, estates and future interests. Right? So if you are a law student, then you probably know about this, and it's given you headaches. Now, what I like about this is actually a good example of thinking that is relatively unique to thinking like a lawyer. This is abstract. It's kind of hard to figure out. There's no real concrete way to deal with it, but it does train your brain to think like a lawyer. All right. So what is this estate and future interest concept that I'm talking about? This is a classification system with roots that go back to medieval England, and it defines different levels of ownership of the land. So fee simple absolute is the most complete form of ownership. You own the land forever with no conditions attached. That's called fee simple absolute. You can sell it, you can lease it, you can give it away, you can pass it down to your heirs. Most homeowners hold their property in fee simple absolute. But there are also lesser estates. There's a life estate, which gives someone the right to use and possess property for the duration of their lifetime. And when they die, the ownership passes to somebody else. There's a defeasible fee, is ownership that can be lost if a certain condition is broken. For example, I give this land to the city so long as it's used for a public park. If it's not used for a park, then the ownership could revert back to the original grantor, the original owner of the land, or their heirs. These conditional estates create what we call future interest, the right to receive ownership in the future when a condition is met or an estate ends. Remainders, reversions, executory interests, the terminology gets dense, but the underlying concept is straightforward. Ownership of the land can be divided across time. And so this is a very legal way to think about land. Co-ownership is another important area. So when multiple people own the same property, the type of co-ownership matters enormously. So joint tenancy is something that includes the right of survivorship. When one owner dies, their share automatically passes to the surviving owner, regardless of what their will says. A tenancy in common is the opposite. Each owner's share goes to their heirs. The difference between the two can mean the difference between inheriting a house and not inheriting a house. And a lot of people have no idea when one applies to their situation. Then in property law, there's something called landlord-tenant law, which affects millions of people every day. The law recognizes different types of tenancies: a lease for a fixed term, a month-to-month tenancy, a tenancy at will. Landlords have obligations too. Then there's something called easements. These are the right to use someone else's land for a specific purpose. So the most common example is a shared driveway. Your neighbor has an easement allowing them to drive across a strip of your property to reach the road. Easements can be created by agreement, by necessity, or even by long-standing use. That's called a prescriptive easement, and it works similarly to adverse possession, which I'll mention right now. Speaking of it, adverse possession is one of the wildest concepts of law. When I learned about this in law school, I did not want to believe it was true. Now that I've taught it and dealt with it a little bit over time, it makes more sense, but it's still kind of wild. So, under certain conditions, if someone openly, continuously, and exclusively occupies a piece of land for a statutory period, so a certain amount of time, between 10 to 20 years, depending on the state, they can actually become the legal owner of the land. The original owner loses their title. And it sounds outrageous, right? But the policy behind it is that the law favors productive use of the land. So in essence, if you have allowed somebody to be on your land for 10 to 20 years and they're open about it, and it's notorious, it's continuous, and it's adverse to your interest, and they are using the land productively, we want the land to be productively used. And if you think back to times when farming was the big deal, right? And we needed to have productive farmland to produce food and things of that nature, and land that wasn't being used in that way was not beneficial to society. That's kind of where this law comes about, or this idea comes about. Then there's real estate transactions in property law, right? Where we talk about the actual buying and selling of property. These are governed by strict rules. The statute of frauds requires that contracts for the sale of land be in writing. The concept of marketable title means the seller has to deliver a title free of significant defects, liens, or encumbrances. Then there's the recording system. This is the way that deeds and other property documents are filed in the county. It determines who wins when two people claim to own the same property. Different states use different recording statutes. There's race statutes, there's notice statutes, there's race notice statutes, and each with the different rules about priority. Mortgages and foreclosures are critical in the real world. When you take out a mortgage, you're giving the bank a security interest in your property. If you don't pay, they can foreclose on the house, right? If you don't pay the loan, they can grab your house, sell it, and take the money back, right? If you aren't able to continue to pay on the loan. That's what a foreclosure is. But you have rights in that process. So now let's talk about personal property. We'll move from real property to personal property. So personal property is every tangible thing you own that isn't land or permanently attached to the land. Your phone, your car, your laptop, your bicycle, the cash in your wallet. These are all personal property. And while the bar exam tests real property as its own dedicated subject, personal property shows up like contracts and torts and criminal law. So understanding how you acquire, transfer, and lose personal property is essential. The first big concept is how you acquire ownership of personal property. So the most obvious way is how you purchase it, right? You buy something and that ownership transfers to you. But there are other ways. A gift requires three things: the donor's intent to give, actual or constructive delivery of the item, and acceptance by the recipient. If your grandmother says, "I want you to have my ring," and hands it to you, that's a completed gift. But if she says, "Someday I'll give you my ring," and never hands it over, that's just a promise. And promises to make gifts in the future generally are not enforceable without a contract. So the distinction between a completed gift and an unfulfilled promise catches a lot of people off guard. There's also finding of personal property. So what happens when you find someone else's lost property? The law distinguishes between different categories. Lost property is the property that the owner unintentionally parted with. They dropped their wallet without realizing it. A finder of lost property generally has rights superior to everyone except the true owner. That means if you find a thing and it's lost, it's in a place where like nobody meant to put it there, and that you pick it up, you can claim ownership to it. This is in common law. There are some different state laws that apply to this, depending on what state you're in. You can hold on to it unless the true owner shows up and proves that they own it, then you have to give it back, right? Because we want people to use personal property. It's kind of like that adverse possession I was talking about earlier. We wanted people to use real property. We want people to use personal property. And if there's no hope to get it back to the original owner, then we want somebody who's claimed lost property to be able to use it. Then there's mislaid property. This is property that the owner intentionally placed somewhere and then forgot about it. You set your phone down at a restaurant table and left without it. With mislaid property, the owner of the premises where it was found typically has the right to hold it for the true owner, not the person who found it, right? So you don't have ownership interest in the new item. When it's lost, you have an ownership interest, but when it's mislaid, you're just holding on to it till the original owner comes back. And abandoned property is property that the owner intentionally gave all rights up to. So they threw it in the trash. Abandoned property belongs to the first person who takes possession of it. These distinction matters because who gets to keep found property depends entirely on which category it falls into. So that's property law, both real and personal. It touches your life every single day. It governs your home, your stuff, your creative work, and your financial security. Understanding property law isn't just academic. It's about protecting the things that matter most to you. And now we're going to move on to subject 7 called evidence. Now, evidence law is the rule book for proving things in court. Really what you got to do when you think about evidence rules is that these are the things that keep out all the bad information so that the jury never hears bad information, and brings in all of the good information so the jury only hears good quality facts to make their decision on if somebody is going to be charged criminally, right? Going to be found guilty or not guilty, or in a civil case, they're going to be found liable or not liable, which means they'll probably have to pay money if they're liable and not have to pay money if they're not liable. When a lawyer wants to present information to a judge or a jury, a witness's testimony, a photograph, a document, a DNA test, or a text message, the rules of evidence decide whether that information is even allowed in. These rules exist for one fundamental purpose: to make sure verdicts are based on trustworthy facts, not gossip, not speculation, or emotional manipulation. The Federal Rules of Evidence, the FRE, were enacted in 1975, and they govern all federal courts. Most states have adopted pretty much the same rules as well. And so I'm going to touch on a couple of the rules that you're going to find in a courtroom. And the first one we're going to start with is Rule 401 about relevance. So under 401, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. That's from the actual rule. That's a really low bar. Almost anything that helps prove or disprove a fact in this case is relevant. But relevance alone isn't enough. Coupled with 401 are rules 402 and 403, which will allow you to exclude relevant evidence. So 403 says that even relevant evidence can be excluded if its potential to unfairly prejudice the jury substantially outweighs its value in proving something. So let me give you an example. Suppose someone is on trial for robbery. The prosecution wants to show the jury a graphic, bloody crime scene photo. Is it relevant? Maybe. It might help prove the severity of the crime. But does the emotional impact of the photo risk inflaming the jury against the defendant beyond the facts justified? A judge has to weigh that. 403 is all about a balancing test. So here's how we want the jury to decide. Remember, ideally, when we start the case, the jury has no idea what the case is about other than in a general sense, okay? And then the lawyers who have gathered the evidence and done the investigation, and they've done all the pre-trial motions to make sure they've done all the pre-trial motions to make sure evidence is relevant or not relevant. Now they are presenting the case, right? And these are ideally all trustworthy facts. And so then they lay out their case, and then what we want is the jury to make a logical, reasoned conclusion. We do not want emotion to get into it. Now, we're human beings. Emotions are going to come into it depending on what type of case it is. But ideally, we're trying to minimize that. And so that's what Rule 403 does. If evidence creates some type of emotional reaction, if the evidence creates a strong emotional reaction, we do not want that in. Unless the probative value, or how important it is to the case, severely outweighs that. So that's Rule 401. It's probably the most basic rule and the most important rule. Character evidence is another tricky area. So the general rule is that you cannot introduce evidence of someone's character to prove that they acted a certain way on a particular occasion. Okay, so the idea here is just because they might be a bad person doesn't mean they did something bad at this time or whatever they're accused of. Just because they're a good person doesn't mean they did something good at the time of the thing that they're accused of, right? Bad people can do good things, good people can do bad things. And so character evidence is not necessarily something we want to bring in to prove that they did the thing or didn't do the thing. Because we don't want to judge the person, we want to judge the facts and see if they meet the law to see if they're guilty or liable for that situation. Now, there are some exceptions. Especially in criminal cases. A criminal defendant can introduce evidence of their own good character, and once they do that, the prosecution can respond to show evidence of the bad character. And so that becomes tricky as a lawyer to try to figure out what you want to do and if you want to do that thing. And so now let's move on to the most famous concept in evidence law, hearsay law. You've probably said this, that's hearsay, something of that nature. So what is hearsay? Hearsay is an out-of-court statement offered to prove the truth of the matter of what it asserts. In plain English, this means someone is trying to use something another person said, not in this courtroom, not under oath, as proof of what they said is true. Okay? So in essence, ideally, when we have the perfect situation, and hearsay has a ton of exceptions, but when we have the perfect situation, we want witnesses in the courtroom. You have the right to confront the people who are accusing you of those things. And what we want is somebody to be able to present their case of what they saw or what they experienced, whatever that is. And then we want the other side to be able to cross-examine them, to ask them questions, because people lie. And we don't know if this person is lying or not. And what we have figured out is that the best way to figure out if somebody is lying or not is to cross-examine them. So have somebody who's against their interest, the other side of the court case, ask questions to probe and to see and to check if this person is telling the truth. That's what we want. And so if anything is said outside of the courtroom, because in the courtroom you swear to tell the truth and you can get in trouble if you don't tell the truth. If anything is said outside of the courtroom, we don't want to let that in unless you are the person that said that thing. And then you can identify what you said, why you said it, ask questions or answer questions about it, right? All those good things. So here's an example. A witness testifies, my neighbor told me he saw the defendant running from the building. That's hearsay. Why? The neighbor's statement was made outside of court, and it's being offered to prove that the defendant was, in fact, running from the building. The problem is that the neighbor isn't here under oath, subject to cross-examination. We can't evaluate their reliability. So the general rule is that hearsay is inadmissible. But here's the thing. There are so many exceptions that bar prep experts say when a hearsay question appears on the bar exam tests, the correct answer almost always involves an exception that makes the statement admissible. So here are some key exceptions. Excited utterances. All right, statements made while the person is under stress of a startling event. So the idea is that someone who just witnessed a car crash and blurts out, that guy ran the red light, probably isn't fabricating their account in that moment. So we don't need to have the person in court who said that thing there because it was an excited utterance. The idea is that you don't have time to formulate a lie. Okay? Then there's business records. Records kept in the ordinary course of business are admissible because businesses have an incentive to keep accurate records. So that's an exception to the hearsay rule. They were created outside of court, but they are meant to be accurate for their own business. The business needs them to be accurate. Why would the business lie about their own records? Right? That's the idea. Dying declarations is another exception. A statement made by someone who believes they're about to die about the cause of their death. So the idea is you're not going to lie about that, right? I guess maybe in movies you might see something like that where people formulate that they can use this dying declaration to possibly get an enemy in trouble, but the likelihood of that is very small. Statements against interest. Okay, so a statement that's so contrary to the speaker's own interest that a reasonable person wouldn't have said it unless it was true. Okay, so that's obvious in its stage, right? Why would you say something that is against your own interest if it's not true? So these exceptions, and there are many more, are based on the theory that certain circumstances make statements inherently more trustworthy, even without cross-examination. Remember, the courtroom is like the ideal place where we're trying to find the truth of the matter. And so we have all these rules and we have all these situations where we're trying to figure out, okay, how do we get truthful evidence in front of the jury so they can make a decision? You'll learn about privileges in evidence class. So privileges are areas where the court cannot force you to talk about things. So what does that mean? Attorney-client privilege means your lawyer can't be forced to reveal what you told them in confidence in the courtroom. A spousal privilege means your spouse generally can't be compelled to testify against you. We want the bonds of matrimony to remain true to each other, right? We don't want to force spouses to testify against each other. These privileges exist because society has decided that protecting the confidentiality of certain relationships is more important than getting every piece of evidence into court. Finally, expert testimony follows its own set of rules, right? So under what we call the Daubert standard, the judge serves as a gatekeeper. They have to determine that an expert's methodology is reliable and relevant before the expert can even testify. This prevents junk science from influencing juries, right? Again, the juries represent common sense. And so we don't expect the people who make up the juries to have specialized knowledge. And so we want to be able to explain everything to them. But just because you might have common sense doesn't mean you can't be swayed by science or things that kind of look like they're real or they sound great, right? For example, I'm fascinated by the idea of aliens. I love space. I love science fiction. So maybe I'm susceptible to being persuaded by somebody who looks like an expert that aliens really exist. Now, as far as I can tell, they don't. We have no evidence of that. But man, I tell you what, I would like that to be true, right? Because I like science fiction. Well, the judge's job is to say, hey, you know what, this person who might have some ideas, but it's really kind of pseudoscience, we're not going to put them in front of the jury so that some people like me can't be persuaded by that. So an expert has to be qualified, their methods have to be sound, and their testimony has to actually help the jury understand something they can't figure out on their own. So that's the purpose of an expert. So evidence law is what ensures that the truth, and only the truth, is what drives outcomes in courts. If you ever serve on a jury, sit in a courtroom, or are involved in any legal dispute, this is the subject that determines what you'll see, hear, and what gets kept out of the court. Let's wrap up this video with the 8th and final topic, but it is by far one of the more important topics if you are a lawyer that goes into the courtroom. Now, not many lawyers actually are what we call litigators. If you are a criminal defense or a criminal prosecutor, you're going to go to court more than likely. But in civil law, which is a huge area of law, torts and contracts and all the stuff that we've talked about before, there's a smaller likelihood that you're going to go to court. But when you do, this topic called civil procedure rules the day. So civil procedure is the rule book for how lawsuits work. Not what the law says, but how the court system operates. It's the instruction manual. It's the instruction manual. If the legal system is a game, civil procedure is the rule book for those games. Let me make this real. Let's say you slip and fall in a grocery store and break your wrist. You want to sue the store for your medical bills, right? They didn't want to settle. They said it was your fault, whatever. Before anyone even looks at whether the store was at fault, you have to answer a bunch of procedural questions first. Which court do you file in? Do you file in state court or federal court? Do you file in the state where you live or the state where the store's headquarters is? How do you officially notify the store that they're being sued? What paperwork do you need to file and when? And what's the timeline? If you get any of those wrong, your case could be thrown out before anyone even hears your argument. That's how powerful civil procedure is. This is where you hear a court was thrown out on a technicality. It's about the procedures. You didn't follow the proper procedures, so you throw it out on a technicality. We didn't look at the actual law to see if they were wrong about the law. You were thrown out because you didn't do the right things like you were supposed to do. They're equally important, right? Because we don't have a process that's consistent over time that we can rely on and we understand the timeline. We can't efficiently litigate and figure out who's right and who's wrong in these situations. So there has to be some type of structure, and that's what civil procedure provides. So the rules come from something called the Federal Rules of Civil Procedure, the FRCP, which I will not use that acronym. There are 86 of them, and they were first adopted back in 1938. Rule 1 states that the purpose in plain English is to secure the just, speedy, and inexpensive determination of every action and proceeding. Most states model their own rules after the federal version, so even if you're in a state court, you're dealing with something very similar. So let's talk about some key concepts here. First, jurisdiction. This is a question of whether a particular court even has the authority to hear your case. There are different types. Federal question jurisdiction means that the case involves a federal law, something like a constitutional rights violation. Diversity jurisdiction is when citizens of different states are suing each other and the amount at stake is over $75,000. And then there's personal jurisdiction. Does the court have the power over the specific person or the company being sued? That depends on whether they have enough minimum contacts with the state. A company that does business in Michigan can be sued in Michigan. A company with zero connection in Michigan probably can't. Think of jurisdiction as having the power to enforce the rules, right? So if you are a teenager living in your parents' house, your parents have jurisdiction over you, right? They have personal jurisdiction. They have authority in the house. It's called subject matter jurisdiction to handle any of the problems. And wherever you go as a teenager, if you go to school, if you go to the store, they still have jurisdiction over you because they're your parents, right? But if you were over in your friend's house, your parents don't have jurisdiction to make the rules in that house. That's your friend's parents, right? They have jurisdiction in that area. And so they get to enforce the rules. Now, that's not a perfect analogy because parents have power over their kids pretty much anywhere they go. But you get the idea of the two different houses, right? One, your parents make rules in this house and your friend's parents make the rules in this house. And they might be different and they're enforced by those parents. Your parents cannot enforce rules in your friend's house. They might be able to make you do certain things, right? And that's where this analogy isn't perfect. But they don't tell the parents of the other house what rules they should make, right? Now, there's another concept I want to talk about, discovery. This is the phase where both sides exchange evidence during the trial. So there's things like depositions, where you sit a witness down under oath and ask them questions. There's interrogatories, written questions that the other side has to answer. There's document requests, where you have to hand over every email related to this transaction, right? And this is like in a criminal investigation, you're talking investigation, right? This is where the police go and interview witnesses and all that stuff. This is the similar process in a civil procedure type of way. So in the modern world, e-discovery, searching through massive amounts of electronic data, text message, emails, and cloud storage is part of this process. Here's a stat that blows most people's minds. Discovery is so effective at revealing the strengths and weaknesses of each side that roughly 95% of civil cases settle before reaching a courtroom. So part of what you're doing here, right, is you think you have a court case. And so you file and you file all the proper procedures, and the court says, yep, this is good, and okay, we're going to do this thing. All right, now we're in discovery phase. And because it's under the court's authority, the court forces people to give all these documents. And then you start to research the documents. And the lawyer looks at it and says, okay, yep, we really have a strong case. Well, if you have a strong case and you're the person doing the suing, that encourages the other side to say, you know what, they do have a strong case. Let's settle, meaning let's come to an agreement between the two sides before we get to trial. Because the problem with trial for a lot of people, especially if they're the people being sued, is the jury is an X factor. We don't know how much the jury is going to charge us, right? If we lose, what is the penalty going to be to us? But if we settle, we can negotiate it between us, and we can set the number. And if we don't like the number, then we can go to trial. But most of the time, as we said, 95% of the time they settle, you get to a number that they can handle. And on top of that, there's benefits. When you settle, you don't have to make it public. That's a big deal, right? So the trial you see on TV, that's an exception, not the rule. All right, a third idea in civil procedure are motions. These are requests that asking the judge to make a decision. A motion to dismiss says, even if everything the other side claims is true, they still don't have a valid legal case, right? In essence, what you're saying with a motion to dismiss is, here are the elements that they have to prove. They've given all the evidence for it. They can't prove it. Let's get rid of this. A motion for summary judgment says the facts are so clear that we don't even need a trial. Just rule in my favor now. These motions can end a case before it ever gets to jury, and there's all kinds of other types of motions as well. And finally, the claim and issue preclusion. This is a really interesting topic that I like to teach. Once a court has decided something, you can't relitigate the same dispute over and over. You get your day in court, and then it's done. This prevents the system from being clogged with people endlessly refiling the same case, hoping for a different outcome. All right, so once your claim has reached all the way through and you've gotten a ruling, you can't go back and say, hey, you can appeal. You can appeal, say, hey, we don't think this was the right idea, but you can't come in with a whole nother case on the same topic. So civil procedure exists to protect something that's actually in the Constitution, due process. Due process means you pretty much get a trial or something like that. People can't just take things from you. And when I say people, I mean the government. The idea that nobody should lose their rights without a fair chance to be heard is due process. Procedure is what makes the fairness possible. Okay, so those are the 8 core topics that you're going to find in most law schools to prepare you for the bar exam. But here's what I want you to understand. In the real world, these topics don't exist in isolation. They overlap constantly. So take a single criminal case. The police search a suspect's apartment. That's criminal procedure, specifically the Fourth Amendment. They find evidence of a crime. Criminal law defines what that crime is. At trial, the defense argues that the evidence should be thrown out because At trial, the defense argues that the evidence should be thrown out because the search was illegal. That's evidence law intersecting with criminal procedure. The judge has to decide whether the defendant's constitutional rights were violated. That's constitutional law. And the whole trial follows specific procedural rules. That's civil procedure principles applied in a criminal context. Or take a real estate dispute. So the first one was criminal area. This is a civil area. So the real estate dispute. Someone buys a house, and 6 months later the foundation starts cracking. Was the sale agreement valid? That's contracts. Did the seller know about the problem and lie? That's torts, specifically fraud. Who actually holds title to the property? That's real property. And where do you file the lawsuit and what procedures do you follow? Again, that's civil procedure. So every real world legal problem pulls from multiple subjects. That's why lawyers need to understand all 8. And it's why learning them gives you a massive advantage in understanding how the world actually works. So here's what I want to leave you with after watching this video. And if you watch the whole thing, I appreciate it. Most people go their entire lives without understanding the legal system that governs everything they do. They sign contracts without knowing what they're agreeing to. They interact with police without knowing their rights. They rent apartments without understanding the protections as tenants. They hear about court cases in the news and they have no framework of understanding of what's happening or why. You don't have to be one of those people. At Law School for Teens, I teach these concepts to teenagers using real scenarios. The same foundational knowledge that lawyers spend years and hundreds of thousands of dollars to learn, broken down so you can understand and apply them right now. We don't just memorize the rules. We work through real fact patterns. We analyze both sides of the ambiguous cases and develop critical thinking skills and make you sharper in every area of your life, whether you end up becoming a lawyer or not. If you want to be a lawyer someday, this gives you a head start that most people don't get until their first year of law school. If you never want to step inside of a courtroom, that's fine too. You still understand the rules that shape your rights, your money, your property, and your freedom every single day. And your thinking has improved drastically. Check us out at lawschoolforteens.com, and I hope to see you in class. Thanks.